Title 4, Crimes Against Property. Chapter 26, Blackmail or Threatening Letters. Section 485. Definition. In practically all jurisdictions it is now an offense to obtain money or property from another by threatening injury to person, property or character. This is ordinarily known as blackmail. It is possible that such offenses were punishable at common law, but today the offense is entirely statutory, and it is necessary in any jurisdiction to go to the statute in order to find just what acts are indictable thereunder. The earliest English statutes related to the sending of anonymous letters demanding money or property, and threatening injury for non-compliance. Section 486. What kind of threats are indictable? Generally speaking, threats to accuse one of crime or of committing gross misconduct not criminal, to set fire to property, to do personal violence, to injure one's business, to begin a criminal prosecution, to accuse one of something which would bring him disgrace or contempt are indictable. Section 487. Purpose of threats. In order to convict under almost any blackmail statute, it is necessary to show that the threats were made for the purpose of obtaining money or something of value, or the inducing of another to do something against his will, that they were communicated to and intended to be communicated to the person against whom they were directed, and that the threats were of a character such as to produce in a reasonable mind alarm or bodily fear, and of a nature to take away the voluntary action which constitutes consent. It is immaterial whether any advantage be actually gained by the threats. Under most statutes conviction may be had for oral threats as well as written. Threats by gestures are insufficient. It is immaterial whether the thing threatened was to be done by the accused or another. The venue of the prosecution, where the threats were made by a mailed letter, may be laid where the letter was received.